Any mention?
No unlisted, Mr. Yubin.
Monday, my lord. There's a young boy who wanted to take admission in MA Political Science, my lord, and he suffers from intellectual disability, my lord, 45%. Yes, my lord. And now horizontal 5% reservation is supposed to be given under the horizontal and under the act. That's
of course. We have to be alive to mental disabilities.
My lord, I'm so obliged, my lord.
There's no health without mental health. You know?
Madam Monday,
yes.
Obliged.
Yes.
May I please, Your Lordship?
Make it quick.
I beg to mention item number 32 as the counsel for the petitioner is out station. D. Marpan. S. Marpan.
Yes.
S. Marpan. He is out station, Your Honor.
Yes, yes. How long? 1 week.
Yes.
Who's the other side? No objection. Yes. Yes.
Please, Your Lordship. Lordship, I beg to mention item 30 and 31. Lordship, these matters may please be for the mediation, Lordship. 30 and 31.
Give the order, yes. Okay. Mediation. You agreeable?
Yes, Your Lordship.
Okay.
Obliged, Your Lordship. Please, Your Lordship.
The same order, I mean. Yes.
I beg to mention item number 28, Your Lordship.
28, yes.
Mr. SN is not.
Mediation.
No, Your Lordship. Mr. SN is not available, Your Lordship. Mr. SN, Your Lordship, is not available.
Also the petitioner. Number 28.
L. Shangwan, Your Lordship.
SN Suna. Any objection to adjournment? Does that matter regarding that?
Yes, Your Lordship. Mintudu River.
We'll have it next week, yes.
Yes, Your Lordship. A week's time.
1 week, yes. Yes.
Much obliged, Lordship.
Yes.
I'd like to mention memo, my lord. This matter I'm mentioning, my lord, for listing on Monday for referral to the mediation, my lord. For Monday, my lord.
It's not on the list.
It's not on the list, my lord. Deeply.
Yes. 31 mediation.
May it please, Your Lordship. I beg to mention item number 42, Lordship. This matter is for reference also, Lordship.
This 42.
Yes.
You agree with mediation?
Yes, Lordship.
Because the title suit's over.
That is not yet over, Lordship.
We have a very limited role, my lord.
Yeah, then anyway, don't agree with mediation. Yes, we'll list it after 2 weeks.
My lord.
Yes. 30, 42, yes. Yes.
Please, Your Lordship. Your Lordship, I beg to mention one unlisted matter to be listed on Monday.
What's the matter about?
Your Lordship, we filed writ challenging disqualification for off-technical bid. However, during dependency the respondent opened the financial bid of tender. So, as such,
the matter is already pending. Was for fresh filing.
Your Lordship, the main case is on.
There's already
28.
a case pending here. What's the name of the parties?
MSACC Logistic versus Union of India.
Okay, the transport. Yes, okay, Monday.
Yes, Your Lordship. Yes, Your Lordship.
Yes.
Please, Your Lordship. Should I beg to mention item number 33, my lord. 33. Conducting counsel Mr. SN is 33, my lord. 33.
Yes.
And for the private respondents number 8 to 12.
1 week.
1 week, yes.
Mr. Sen is not here.
No.
Yes. Mr. Snaitang will have no objection. I don't like doing hearings. Yes.
Mr. Thapa, Lordship.
Mr. Thapa, he also doesn't like to do hearing. Only he wants to do fresh. You know, like
this
that.
matter can be sent to mediation also.
Send for mediation.
It can be sent.
Okay,
and for the corporation, my lord, here.
Yes. You want to sign the form, Mr. You know, whoever has agreed mediation, you all sign the form.
No, my matter wasn't, sir.
Why? Yes, there's a format, okay? Like if you agree with mediation, you have to sign it because the time and date will be informed to all of you. Yes.
We'll do that, my lord.
Yes. The program is called Mediation for the Nation. I think you all know. Yes.
Supplementary list item number 1.
What is this?
Lord, this matter pertains to, Lord, the election in the Janta Hills Autonomous District Council, my lord.
Election.
Yes, my lord, the conduct of elections, my lord. Now, my lord, there were a lot of lapses, my lord, in the conduct of fair and free elections in the GHDC, my lord. In fact, my lord, prior to the elections, we had made a representation, my lord. We had given intimations to both the district and the Janta Hills, my lord, pointing out the sensitive polling stations, my lord. Now, despite our intimation, prior in hand before the elections, my lord, steps were not taken by the my lord, authorities to ensure free and fair elections, my lord.
So you mean to say that because of what happened, that your candidates lost or something like that?
No, my lord. We are not questioning the outcome of the elections. Then what had happened is, my lord, during the my lord, prior to the elections at page 18.
Let's see your prayer.
Yes, my lord. My prayer is, my lord, for my lord, conduct of independent inquiry, my lord.
What's
and assign
process of elections, Mr.
My lord, and assign, my lord, accountability, my lord, on the failure on the part of the authorities, my lord. Now, my lord, as far as the my lord, central election and the state elections, there's an election commission, my lord. Now, as for the district council elections, my lord, there are rules. These are called, my lord, the Assam Meghalaya Autonomous District Council Constitution.
Rules, yes.
Yes, my lord. So the elections are held under these rules. These rules are also comprehensive, my lord. They also talk about, my lord, failure to conduct free and fair elections. So, my lord, pursuant to the elections, now it is undisputed, my lord, that there were several incidents, my lord, that happened. And it is only in 4 polling...
One thing, Mr. Ramli, at that point of time, when he said incidents, was it reported to the authorities?
Yes, my lord. It was reported, my lord. It was reported. And in
what
fact...
action was taken?
My lord, no action has been taken. Thereafter, my lord, we made a representation which lordships will find at page 26, annexure 9. For conduct of inquiry, my lord. This is our representation pursuant to the elections.
Yes.
On the failure of the state government to ensure free and fair elections, and for not proper deployment of my lord, security. Now, my lord, by this representation, we had sought for, my lord, this representation was, my lord, made to the chief secretary and also to the commissioner and secretary.
What happened after that?
My lord, now they have not acted on this representation. All they have done is, my lord, given a reply, a justification, my lord, to say so, my lord. Now there were various my lord, justifications, my lord, that in terms of, my lord, in those 2 or 3 polling stations where repoll was conducted, they have filed sumoto FIRs. But what about the other incidents in the other my lord, places where the polling officer was not able to, my lord, handle the situation, my lord?
So what do you want now? You want to,
my lord, an inquiry,
accountability to
yes, my lord. It has to, my lord. It has to, because it's not only one elections, my lord. It is, my lord, in future elections also. If your lordships kindly have the rules. I have only printed the, my lord, relevant portions. If your lordships kindly have internal page 76.
Yes.
So, my lord, this chapter starts, my lord, it starts from, if your lordships kindly have internal page. Yes. Page 70, my lord, after the index. These are the general provisions, my lord, for holding of elections in the district council, my lord. Yeah. Rule 124. Then your lordships, internal page 76.
Returning officer.
Yes, my lord. At rule 130 provides for, my lord, list of returning officers, and rule 131 appointing of additional returning officers.
Yes.
Thereafter, my lord, all these provisions, my lord, for voting and everything, my lord. And at
where is that provision we are saying will not allow for such
yes, my lord. Now, rule 143, my lord, talks about duties of the presiding officer at the polling station. Rule 143(1) reads, my lord, presiding officer shall keep order at the polling station and shall see that the election is fairly conducted, and shall regulate the number of votes to be admitted at one time, and shall exclude other persons except so and so, my lord. So it is the duty of the presiding officer, my lord.
Reading 143.
143, my lord, page 88, internal page 88. So, my lord, it is the duty of the presiding officer to keep order at the polling station, my lord.
Yes.
Then, my lord, Rule 143B provides for fresh poll in case of destruction, etc., of ballot boxes. So around 4 or 5 polling stations, my lord, re-poll was conducted, but the rest, my lord, nothing was done. Now, my lord, kindly have internal page 111, Rule 179 provides for election petition. If we are aggrieved by the outcome of the election, we can file an election petition. We are not aggrieved by the outcome, my lord. What we aggrieved by is that there was no fair and proper elections, my lord, conducted.
No, but that means indirectly you mean that if these things hadn't happened, the results would have been different. Is that what you're implying?
No, my lord.
It's a roundabout kind of litigation.
No, my lord. The state government has failed its responsibility, my lord.
To the fact that
yes,
it's been quite a political party.
Yes, my lord.
Okay, this writ petition.
Yes, my lord.
But then it is not clear as to what relief you really want.
My lord, we want
whether you can seek this kind of relief now.
Yes, my lord.
Was there any election petitions filed?
No, my lord. No election petition.
No, not by
because this is not an individual, my lord. It's not an my lord, individual grievance with respect to the outcome of the election. This is regarding the entire election, my lord, conducted in the Janta Hills, my lord. That it was not properly conducted and somebody has to be held accountable to that. Your lordships may kindly have internal page 130, rule number 204, my lord. Breaches of official duty in connection with election.
One second.
Sub rule 3, my lord. The persons to whom it applies, returning officer, additional returning officer, presiding officer. So, my lord, inquiry should be.
Yes, reading from page?
Internal page 130, my lord.
Yes.
Rule 204. Breaches of official duty in connection with election, my lord. So this is what we want, my lord. Some inquiry has to be conducted, my lord, and my lord, accountability has to be.
Will this amount to what do you call it, a polling station, whatever breaches of official duty in connection with election?
Yes, my lord. They have to. It says, my lord, all these rules. Sub rule 1 reads, my lord, if any person to whom this rule applies is without reasonable cause guilty of any act or omission and breach. So any rule, my lord.
But at a point of time,
yes,
complaints made for returning officer.
Yes, my lord.
At that particular polling station.
Yes, my lord.
You annex them here.
No. My lord, your lordships will find.
See, what election process demands what? Demands that suppose at any polling station there's some undue influence being caused, some briberies being caused, some impersonations being caused, or some, any kind that might affect the cause of free and fair elections. Then at once, the candidate or anyone there, he makes a complaint to the presiding officer there, which is in turn taken up by the returning officer. And if the circumstances are so, then the voting is closed in that
in fact, my lord, if your lordships kindly have.
Because you can't generalize that, entire Janta Hills, that the elections were rigged, that is what implying.
No, my lord. I'm saying, my lord,
there was not free and fair elections.
My lord, I have listed these sensitive polling stations, my lord. Not all the polling stations.
Yes, Mr.
Now, no action was taken, my lord.
At this stage, may I submit, my lord? Two things, my lord, because this is a political battle which they are trying to fight in the court, my lord, because they have lost the election. 2 grounds, my lord. Kindly see. First, my lord, your lordship has correctly summarized that all these issues could have been challenged by way of election petition if there was some issue, my lord. But be as it may, my lord, before I take your lordship to the kindly see their representation and decision by the government, my lord. I was just kindly come to page 28, my lord. 28, where they have gave the representation and we have given the detailed reply, and there is no whisper, iota, anything regarding this, my lord. If you lord, 30th June, my lord,
Yes.
With reference to the above, as directed, it is to be informed that relevant steps and actions as indicated below were taken in connection with recently concluded election of Janta Hills Autonomous Council, which was held on 21st February 2025. That election of KHADC was notified on 27 January 2025, where the date of poll was fixed on 21st February 2025, and prior to the announcement of election, vulnerability mapping of all constituencies were conducted by district administration. Same was carried out more than once. Based on the assessment mentioned above, respective district administration proactively undertook a series of preventive and security measures aimed at ensuring that no individual or groups could disrupt the peaceful, fair and election aforementioned. These measures included enhanced coordination with law enforcement agency, increased deployment of security personnel in sensitive areas, setting up the surveillance mechanism, and instilling public confidence in the electoral process. However, during the process of preparing for voting wall, so on 14 February was received from the voice of people urging provide security arrangement for free and fair exercise of right to vote by electorate when as per party assessment. Subsequently, police headquarters, while later it in 17 February directed all SPs to undertake confidence building measures and increase the number of checkpoints and nakas so as to ensure free and fair and peaceful conduct of election. It may be mentioned that Superintendent of Police Janta Hills initiated confidence building measures time to time, maintain public trust and ensure secure electoral environment. Additionally, all polling stations within districts were reassessed to re-evaluate and enhance security arrangement as deemed necessary, and polling stations as Limpau and Thangen were re-categorized as normal police station to vulnerable police station. Similarly, a deployment plan was also made in the office of SP in Wangpungskur and polling station Muisiang Arangat constituency and Batao B under the Batao Lakadong were treated as vulnerable polling stations. The sufficient staff as per deployment plan, 3 personnel along with 1 SI, 1 ABI were detailed as zonal and sector officer for these constituency. Their constituencies names are there. And lastly, moreover, a quick reaction team was also detailed with sufficient staff in station nearby location in order to meet the emergency call. Prior to polling date, Office of SP is instructed all OCs and ICs.
Yes, okay, we've seen that.
No, Your Lordship, kindly come.
Normally, in these kind of matters is that when election petition is filed, what is the system or the procedure is that when there is an election dispute in a district council, the tribunal is constituted by the government.
Yes, ma'am.
To hear election disputes.
Yes, ma'am.
And in that tribunal itself, such allegations, then
that is on the outcome. That is on the outcome
because it's all on facts. You see, disputed facts. That is why it goes out. Even if it shows that what happened there didn't materially affect the results, but the very fact that there's been some disturbance or what happened that day, your witnesses can be called. And by roving kind of writ petition,
it's undisputed fact, my lord, that certain events happened, repolled had to happen, my lord.
Admission hearing,
Your Lordship, the Mohinder Singh Gill judgment, my lord, way back in Supreme Court has said that 226 cannot be invoked for these matters, my lord. Lordship may put it for preliminary objections or on maintainability, my lord.
Mr. Nombri, you should notice that the Advocate General with
because it is not maintainable, my lord. This writ is not maintainable. It's a political battle which they are trying to fight.
I have made a representation. They have to deal with it.
They have.
So will be forwarded.
Yes, except what about number 5 and 6?
Lord, notice will have to.
Selection. Thank you.
This is who's the district election officer at that point of time?
It's a deputy commissioner, my lord. It is.
My lord, I think the learned AG can represent all of them.
All of them?
Yes,
yes,
all government.
Advocate General with so present accepts and representing all the respondents for the notice called for. As the substance of the matter involves a challenge to the conduct of free and fair elections, which the Advocate General submits has elections. The question of maintainability hangs over the writ petition under 226. Accordingly, it's a matter of admission hearing. Respondents permitted to file a objection on maintainability. Yes.
Grateful.
Deeply.
Item number 2.
Yes.
My lord, in this matter, my lord, the petitioners, my lord, the Dorbar Dong of Nongrimba, my lord, one of the my lord, localities in Limekra Dorbar Pullun, my lord. Now, my lord, over the years since 2019 onwards, they have been seeking for upgradation as a separate village. Now, in pursuance to the request,
Come before this court.
yes, my lord. The issue here is, my lord, what has happened now is the political appeal has been decided, and the EC has delegated the power of this aim to conduct a, my lord, public hearing to the Shnong, my lord, which is, my lord,
But if it involves creation of a new village, then the parent village has to give consent.
No, my lord, but let's have a look at the provision of the Act, my lord. Your lordships kindly have page 190 and Annexure 35. $190, my lord, Annexure 35. Relevant portion is, my lord, section 3 at page 191.
Yes.
My lord, section 3 provides for creation of new village, formation of a new village and alteration of areas, boundaries or names of existing village. The chief and his darbar, with the approval of the executive committee, may, if the majority of the people of the village or villages so desire by public notification, do so and so, my lord. So, my lord, it is the chief and his darbar who has to, my lord, undertake this exercise. Now, kindly have the impugned order, your lordships.
Chief of darbar with approval of, Yes.
My lord, kindly have the impugned order at page 183, Annexure 32.
183.
183, my lord.
Yes.
Now, what had happened is, my lord, this aim had issued my lord, an order for holding of a public hearing in relation to the upgradation of this particular locality, my lord. Against that, my lord, a political appeal was filed before the my lord, EC.
By you?
No, my lord, by the village, my lord.
Okay.
The entire village. Now, in those proceedings, my lord, the notice of the aim was stayed, and during the pendency of those proceedings, the EC passed another order, my lord, parallel to what the proceedings, directing this aim to go ahead with the public hearing, my lord. So, my lord, aggrieved by that, the Shnong then approached this honorable court and challenged the particular order.
Okay,
we appeared, my lord, and even a district council appeared, and in all fairness, all of us agreed that let the political appeal be decided. So, my lord, now this political appeal has been decided. Now, your lordships kindly have page 184, last paragraph.
Yeah.
So, my lord, after considering the facts, my lord, the EC then, my lord, refers to section 3, last paragraph, my lord.
Yeah.
Refers to section 3. Thereafter, my lord, the effective portion of the order is at page 185. So, my lord, the first direction that has been given by the EC is the interim order to stay the impugned order so and so issued by this aim is made absolute. So, the notice of this aim to hold public hearing has been made absolute. Please state. The second one is what is, my lord, disturbing me, my lord. The second direction, the Darbar Limekra Pullun is directed to conduct the public hearing at the earliest possible. Now, my lord, this power of holding public hearing cannot be delegated to the village, my lord. It is the same who has to undertake this entire process. This is my grievance, my lord.
But the objective is the same, because the thing is that in creation of villages, that the whole village or the Darbar Pullun has to convene, and if the majority of the residents say that yes,
my lord,
locality can,
yes, my lord, holding of the public hearing is not the problem. The public hearing is to be held by whom is the problem, my lord. A coordinate bench, my lord, a coordinate bench.
On receipt about information of outcome public hearing as well as report observers, the same shall take decision by passing order.
Yes, my lord, a coordinate bench of this honorable court, my lord, in 2013 in relation to Nongstoin's aimship has also, my lord, examined this issue. And in that particular matter, my lord, it was left to this aim to, my lord, conduct the entire
order then.
No, my lord, the exercise has to be conducted.
The thing, objective. See, one thing, if we understand, if we look into, to look at, okay, complete justice in a way.
Yes.
Whatever. Now, procedure demands that, okay, that the order should come from the same for convening the public darbar. Procedure demands that. Now, what will be, what will happen is that there will be a public darbar. Correct. Now, what is order has said? Only have public darbar inform the same.
No, my lord. This is not an election. This is not an election. My lord, kindly have, my lord, number 3, direction number 3. The office of the Himamalayam is also directed to depute an observer, my lord. It's not an election. Where, my lord,
modified order, Mr.
The same can.
Why the district council also had passed the order?
It's like supervisory. Whether they have the power to regulate. So
yes,
another thing.
They don't have, my lord. They don't have. Under the Act, they don't have, my lord.
We'll come to page 105. What prompted the district council to pass that order? Now, the same in the earlier occasion had passed this particular order, 105. The Darbar of the CMO Milliam has received the request from the Nongrimba for an upgrade to the status of full-fledged village under Limekra Pulun. In order to clarify matters and to understand the collective will of the residents of Dong Nongrimba, Limekra, Hima Milliam Shillong, a meeting has been scheduled on 10th August so-and-so at Nongrimba Community Hall, Kam Indoor Stadium. The ministries of this Darbar will present to conduct the proceedings of the Darbar at Dong Nongrimba, Limekra, Hima Milliam Shillong. So this was factually, it was incorrect.
Incorrect.
It is not the Dong Nongrimba, it is the Darbar.
This direction can be given.
Notice to the Darbar Shillong of
Let notice be issued, my lord. But in the meantime, the public hearing should not be conducted because if your lordships kindly have page.
Yeah, otherwise I stay in a locality, they might stone my house.
my lords will also have to attend, my lord. Will kindly have
part of the Darbar.
Will kindly have page 188.
Correct. I see. Yes. If I'm a resident, I don't think I can take up this matter then.
Leave it to your lordships. If your lordships, it's purely on question of law and delegation of power. At page 188, the same as directed.
Okay, Mr. Phinon Nongri, Leonard Council petition issue notice. Mr. Leonard Council with Mr. Pariat, accept notice on behalf of respondents 1 to 3. Notice to go to the remaining respondents within 3 days. Stop the grievance as projected by the writ petitioner is with the direction contained in the order dated. Order dated
June 7th of June 2025.
2025 passed in political appeal case number 2 2024, wherein it has been at direction number 2 thereof the executive committee had directed the orders directed the Darbar Limekra Pulun to conduct a public hearing at the earliest with regard to the prayer for creation of new village Nongrimba. It is submitted that this power vested with this aim, as he is the authority, as he is the competent authority under the Act to issue such a direction. It is therefore prayed that in the interim that this portion of the order be stayed.
My lord.
Be stayed. Yes, until next date. Yes. Mr. T.T. Ringdo, Leonard Senior Counsel, submits that the order has been passed with the objective of ensuring for ensuring a fair procedure, free and fair procedure with regard to the request for creation of the new village. He prays we allowed how much time you can put an affidavit also.
Small affidavit.
Yes, prays will put in a small short affidavit
within a week's time
on the prayer made by the petitioner. He prays for allowed 1 week's time now. Having called a counsel for the parties and on hearing the counsel of parties, it appears that at this stage a prima facie case is made out for some interim orders. Accordingly, it is directed that until the next date, the Darbar Pulun of Limekra shall not hold a public hearing. Yes, that there shall not be a public Darbar with regard to the matter concerned. Yes.
Item number 3.
Yes.
Please, Milords. Milords, the only issue in this matter is, Milords, whether the notices issued on 6/6/2025.
What instructions you got? Did you go to approach the...
Milords, in so far as the instructions that was made, the regular bills that had been raised, Milords, by MEPDCL, some of them, Milords, the due date was within these last 2 days. So to that extent, Milords, payments have been made because there is no default in so far as regular bills are concerned. Now, what they do, Milords, I have the copy of the bills here.
11 on Monday. Mr.
Milords, we are in complete darkness. Milords, there are families.
They have not
what
paid,
they have done is
they have not paid for 1.5 years, Milord. They have obtained stay time to time. As a matter of fact, Milord, respond number 3 is a gross abuse, Milord. I will demonstrate it is a gross abuse. Respond number 3.
Just one issue.
Respondent number 3 has already paid it.
No, not respondent 3, Milords.
Green Valley has paid it. I have
not the Green Valley, Milords. I have this is the kind of instructions we have, Milords.
Green Valley has paid
at least 5 companies before your lordships, Milords, have paid
basically,
in the last 2 days.
There are 2 companies, Milord.
In the last 2 days, Milords, out of 7 companies before my lords, 5 companies have paid. We have the receipts. And they have reconnected also. The issue that remains, Milords, is whether the notice at Annexure 1 is a notice under Section 56. I had restricted myself.
That'll involve a lengthy hearing.
It won't, Milords. It won't. Why I'll say, Milords?
It will record, Milords.
Why, Milords? Show me the notice under 56.
Whether that, that the letters are served upon you will constitute sort of a notice.
Why it won't, Milords? I'll try and make it a little easier for all of us, Milords. These are notices issued by MECL in other proceedings, Milords, to other petitioners, and I have 2 copies of 2 different notices, Milords. Milords, may kindly...
2012.
They have the notice, my lord. They have the notice. They know the amount.
May I just finish? My learned friend would have a lot of answering to do. I'm sure my learned friend. My lords may kindly have a. My lords may kindly produce this.
This is everything is an concealment, everything, and abuse of process.
Absolutely
continuous.
Absolutely.
Now you don't abuse each other.
We just stop short of that, my lords, every time.
No, my lord. This is my lord.
My lords, may I just?
I will show.
Let him. I'll give him 2 minutes.
Yes, 2 minutes. Because I feel that
I'll give him 2 minutes. Yes.
My lords, may kindly peruse this notice. This the first one, my lords, I've shown is of 2012.
Yes.
This is issued to a certain company called Kamakshi Ispat, who's nothing to do with this proceedings, my lords. So, my lords, may kindly see with reference to the subject cited above, I am to inform you that an outstanding energy bill is unpaid for accumulated to so-and-so, undisputed as on so-and-so, in spite of repeated requests made by the undersigned, notice served on you from time to time by the field officers. You have failed to clear the outstanding dues. It has been observed that the monthly payment statement that the outstanding has accumulated due to non-payment, partial payment of the current bill amount, therefore, as empowered under Section 56(1) of the Indian Electricity Act 2003, the undersigned is reluctantly compelled to issue this notice to you under the said Act and request you to kindly make payment of the outstanding amount within 15 clear days from the date of issuing of this notice, failing which power supply to our premises will be disconnected.
Yes.
That's one, my lords. My lords, may kindly have a look at the other notice that I've placed before my lords, my lords.
Yes.
This is again another notice, my lords, which says, if my lords may kindly see again the second part, my lords.
Clearly says 56.
As empowered under Section 56A. Now, in this view of the matter, now may I read, my lords, page 15. Yes. Which they say, my lords, may be construed as a notice under Section 56. It says, my lords, with reference to the subject cited above, in pursuance of the order dated so-and-so passed by the Honorable High Court of Meghalaya and so-and-so, I am to inform you that an amount of so-and-so, an area in terms of the tariff order dated so-and-so passed by Honorable MSERC is which yet to be cleared till date. The said amount is now outstanding for more than 5 months. Hence, the corporation demands full payment of the outstanding amount within 15 days from the date of issuance of this letter. If the matter is not resolved by the time specified above, the corporation reserves the right to disconnect your power supply and commence legal proceedings to recover the debt without further notice. What I'm saying is, my lords, in substance, this is not a notice under Section 56. And, my lords, the law is very clear. Both the Electricity Act as well as, my lords, the MSERC supply code is very clear that if you want to disconnect, there has to be a clear notice under Section 56, limited to this.
Now, under 56, do you have recourse to MSERC?
No, my lords.
My lord,
I'll take your lordships to Section 56. As a matter of fact, that one judgment of the Bombay High Court, my lords, which deals specifically with this issue. They say this power.
Mr. Arvijan is not in the form. That's only thing. Other rules are very specific.
I'll just take my lords to Section 56 first.
2 minutes only. Whatever. I will 2 minutes. I will show how.
May I just finish?
Running out. Yes.
2 minutes.
Finish my 2 minutes, my lords. Section 56, my lords have.
Yes.
Supply regulations.
Yes.
Where any person neglects to pay any charge for electricity or any other sum other than a charge for electricity due from him to a license.
He's given a grace period, right?
15 days.
Yes. That's
So, and Malas, the law is settled. There is no ambiguity in this. That section 56 is mandatory.
Yes, Mr.
And Malas, if your lordship so permit, Malas, I can just place one decision of the Bombay High Court, one paragraph of the Bombay High Court, Malas, which throws light on this issue. Malas, this is.
I'm sorry if I'm hurrying all of you, but.
Malas, Friday, Malas, and Friday, Malas, I'm.
Yes. Which paragraph?
If I may take your lordship to page 65, Malas. This is a full bench of the Bombay High Court, Malas. 3 judges bench. Para 65, if my lords kindly have
Para
it.
65. Okay.
I'm sorry, man. I'll just give the page now.
Yes.
My lords, it's at page 918.
Yes.
Section 56 deals with disconnection of supply and default of payment. Now, where the person neglects to pay any charge for electricity or any sum other than a charge for electricity due to him to a licensee or a generating company in respect of supply, transmission or distribution or wheeling of the electricity to him, then the power to disconnect is conferred, and which power has to be exercised in a manner set out by subsection 1. This is indeed a drastic power that can be resorted to only to take care of a neglect to pay the charge. If there is neglect, then naturally in a consolidating statute enough provision has to be made that the charges are paid regularly. Electricity is a material resource and belongs to the public. It is very difficult for the state to ensure regular supply of electricity to those who require the same regularly. In fact, equal distribution of material resources so as to achieve common good is the constitutional goal.
That there has to be notice under for 15 days because anything can happen.
Clear 15 days.
Because permanent disconnection.
Now, what has happened, Malaj?
See, the thing is that permanent disconnection and temporary disconnection are
is a different issue. That's what they say here, Malaj. Now, it says here. It says it is an extreme measure.
Yes.
Now, the issue is, Malaj, what is happening is, now one of the companies, Malaj, who was not here before your lordship, but was there in the earlier round of litigation, 2 major plants in India, in Meghalaya, Malaj, who have pan-India presence, have actually shut down.
They don't pay electricity bill. I will pay.
Nobody pays electricity bill,
and they are not paying it, Milord. They are no. And they want the.
We are fortunate, Malaj, that the MSCL is not saying, Malaj, even domestic consumers don't pay electricity bills.
They are not paying
only
electricity
the political
bills,
masters probably
and
pay
they come here and they say that, look, I have not received the notice. That is only. They don't. They are not saying.
Okay. We have heard you.
Yes, Milord.
Yes.
Now,
my case is only limited to this, Malaj.
Yes.
If you have to disconnect,
first point, Milord.
56.
Yes. First point, Milord. Who is before your lordship? Kindly see the name of the parties, Milord. Kindly see the name of the parties.
Party's name is?
Your lordship will find RNB Carbide and Ferroalloys, Milord.
Yes.
Then your lordship will find RNB Cement. These two companies are owned by one person only. Then, Milord, Green Valley, I have instruction to say that Green Valley has already paid the entire dues.
Okay.
No, they paid 1.5.
That I have instruction, right, wrong, whatever is that, I have got instruction. Now, who has filed the petition before your lordship? Kindly see page 13. Kindly come to page 13, Milord.
The affidavit.
Affidavit, Milord.
Yes.
I, Rahul Bajaj, so and so. I am authorized signatory of RNB Carbide Private Limited, and I have been duly authorized by other companies to file, Milord. The question is, Milord, where is the authorization, Milord?
Yes.
And authorization by company is only by the resolution of the board, Milord. So therefore, this person is not authorized to file the cases on behalf of the other persons, Milord. That is one. So therefore, all these petitions are inchoate, except because this petition is not maintainable. This petition saying that I am authorized on behalf of other companies, there is no resolution, there is nothing, Milord. At best, he can file a case on behalf of RNB Carbide, Milord. That is my first submission, because this is not maintainable. Now, second, Milord, they have the notices of disconnection. They came before your lordship on earlier round. This is again suppression, very gross suppression, Milord. And they came before, and your lordship said, don't disconnect till next date of hearing. And review was dismissed, Milord. They are not placing these facts. I'm really sorry.
56 ones already complied with.
They have. Your lordship will see next page. Your lordship. Last line, Milord. In the interim, it is provided electric connection to be plant shall not be disconnected until next date. Review was dismissed, Milord. I had the right to disconnect. I have disconnected it.
Yes.
That is the disconnect. And why did not they place this material before your lordship? And look, where is the order, my lord? That they came and they enjoyed the interim order. This is abuse. Now my friend will be jumping.
I will not.
And this is my friend will be jumping.
I will not jump.
Third is, my lord, because a lordship will ultimately see how they are abusing the process, my lord. Your lordship, they came against the tariff order of 24th October 2024.
Yes.
Tariff orders clearly said that they have to pay. They lost the case. They filed the review. They lost in review. They filed the appeal. So we are implementing the tariff order. Now they are saying that no, I need this 15 days clear notice, and the notice should also contain the word 56. That is, otherwise this notice is bad in law and they will not pay the amount. I have discussed, and your lordship will see the notices were there to them. They have not placed, and if your lordship will see, my notices are very clear. If your lordship will kindly see page 15. What more they require?
Your submission is that it's totally outside of purview 56.
Yes, but yeah, this is the case. First, who is RNB to file the case on behalf of other petitioners? Second, my lord, what they are saying is that I need word of 56 in this. Earlier notice had 56. This notice has no 56. Therefore, this is not a notice. They have the 15 days notice, my lord. Kindly see the conduct also, my lord. They come here. Lordship has been pleased to grant them stay against the special tariff order. And the Pioneer was the company which challenged that tariff order also. My lord, kindly see the lordship's previous order also, where lordship has been kind enough to stay that part also, my lord, and then that was dismissed also, my lord. They are not placing all these facts, my lord. It's a court of law, it's a court of equity. They are invoking equity with suppression, my lord. Kindly see paragraph 8.
Yeah.
Paragraph 8, your lordship will see. It is third line, my lord. It is directed that in the interim, tariff difference shall be put on hold till next date. But however, writ petitioner is directed to deposit them on current bills, failing this one. So every direction, your lordship has been dismissed these petitions, my lord. Now again, they are saying that 56 notice was not there. My lord, this is nothing but gross. And what they are saying today is that stay means grant me the entire relief today. Stay means disconnect. Writ is allowed on the very first day, my lord. Therefore, my lord, suppression, material fact.
Dispose of the entire matter.
Yes.
I don't think any submission is
Grateful, my lord.
Next matter, yes.
Well, it's just one issue which will be relevant. What has not been submitted by my...
If something is...
Yes, I've noted down, yes.
Just for the purposes of relevance, my learned friend should have a little patience.
I have a lot of patience now. I am running out of patience in these matters.
As far as Green Valley is concerned, what was submitted is a payment of 1.5 lakhs has been 1.5 crores.
We're not recording that. Just going strictly.
RNB Millets has also made the payments. Insofar as regular bills, all these companies have made payments.
That you noted that current bills are being subscribed.
And what they have done is after we made payments, some of these companies wrote to them and they've restored connection also.
My lord, these are neither here nor there.
No, it's not a question of here, there. What I'm trying to submit, because I'm being accused of suppression, whatever. So I must also point out before your lordships, it's only and it's being used as an arm twisting tactics every time, which the law proscribes. It says you can't use 56 for that. That's all.
Daily list, item number 1.
Ali Braj.
You obtained the name?
Lordship, we've executed the agreement also, Lordship, with the...
Lordship, they had intimated us, they forwarded the agreement, Lordship.
Where?
To the district council.
The name of that respondent number 6.
Yes, Lordship, we've not yet received the...
You've got instructions now?
Lordship, they had forwarded the agreement, Lordship. So now we'll have to place it before the...
No, the thing is that... Where's Mr. Pasanti here?
For notice, Lordship.
You're together with Mr. Pasanti here?
No, Lordship.
Yes.
Oh, yes, Lordship, we appeared last.
Have you obtained the details of that respondent number 6?
Not yet, Lordship, we've not received.
Lordship,
what agreement has been signed? We don't understand.
Lordship, the petitioner and the respondent, private respondent,
they have
executed an agreement. Now that agreement has been forwarded to the district council.
Is before you now?
Before us.
Yes,
well, a copy of that is there?
Yes, Lordship.
Then we'll close it. We'll review.
No, Lordship, because we will have to take decisions.
Exactly.
Lordship, allow the district council to take some steps, Lordship, before closing the matter.
Before disposing?
Before
we'll give you 6 weeks to decide. So whatever outcome will be a fresh course of action again?
Yes, Lordship.
Yes, Mr. Kharkrang submits that the agreement between Darbarshnong of Sokumpor Nen, NEIN, and Darbarshnong Sokumpor Pochnong has since been executed, and the same has been forwarded to the Executive Committee. Respondent number?
Respondent 1, Lordship.
No, your respondent number, Executive Committee is 1.
1, Lordship.
Respondent number 1 for consideration. Parry has been made in the joint letter of the petitioner and respondent number 6.
6.
That steps were taken for recall of the notification dated 2021. Mr. Kharakang submits that as the matters before the District Council, they perhaps may be directed to dispose of the request made by the parties as expeditiously as possible.
Yes.
Ms. Nikpar, Ms. Emal Nungpur appearing for the District Council respondents also submits that it is a fact that the agreement which has been executed on 9 November 2024 between the petitioner and the respondent number 6, between the two villages, is before the Executive Committee. So he submits that the same will be duly examined and appropriate orders passed thereon. In view of these submissions, nothing remains for consideration before this court, and as such it is directed that the District Council respondents dispose of the matter, preferably within 6 weeks.
6 weeks.
Within 6 weeks from the date of this order stuff.
Lordship, but if District Council, then the cause of action still arises, Lordship, for us.
Yeah, of course you can come. There's a fresh cause of action. Some needless to add, if a fresh cause of action arises, the parties are free to agitate.
Lordship.
Okay. On this, as ordered above, the representation of consent closed and disposed of.
Obliged.
Item number 2.
May it please, Your Lordship.
Yes.
Your Lordship, I am humbly praying for 2 weeks' time, Your Lordship. The conducting counsel is Mr. SN is having some personal difficulty, Your Lordship.
Is that Larity?
Yes, Your Lordship.
Yes, my lord, that encashment of bank guarantees.
As Mrs. SN, he is the Archival counsel.
Yes, Your Lordship.
That will discuss this matter after 2 weeks.
Hello, obliged.
Item number 3.
Meet. Lordship, we have filed the reply. I have filed the reply on behalf of the speaker today morning, my lord. I have served a copy also.
Yes. We just received a copy of the affidavit.
What about the other respondents?
Lordship, up for respondent number 2, Mr. Charles Maranga. I would pray for further time.
Why? What is the difficulty?
Lordship, trying to get an MLA is like playing hide and seek.
Yes, affidavit has since been filed by the respondent speaker. Stop Mr. Yes, Dave for respondent number 2, and you?
Some time, Lordship.
For 4, and you for? 2, 3, and 4. So recorded news pray for allowed for the 2 weeks' time to file their respective affidavits. This thereafter and so and so.
Your Lordship, is that in this matter because only for technicality on technical. So it's
in election
I think
matters.
for other respondents you don't need to file the affidavit. So
that's not for you to say. Since you put once you put a challenge, they have to be given a right to reply to the same, whether on technicality or on merits or on facts. I think. Correct. Yes. After 2 weeks.
And whether you want to file rejoinder?
No. We'll see to file rejoinder. We'll examine first, then we will file. Your Lordship.
What do you mean? We'll see.
We will see whether we will file a rejoinder or not.
Brief.
These are connected matters, my lord. 4-2.
Yes, MS Swin.
Your Lordship, I'm appearing on item number 4, 9 to 14, Your Lordship. We will not be filing a rejoinder. Let the matter be fixed for hearing.
After taking so much time.
Once, Your Lordship.
Item number?
I'm appearing on item number 4, 9 to 14.
9 14. And Mr. Gautam?
I'm appealing for 5 to 8. I'll be filing a short rejoinder.
Yes, MS this one appearing items number 4, 9 and 14 submits that no rejoinder will be filed. Stop the matter be posted for hearing. Mr. K. C. Gautam appearing in items number 5 to 8. Our praise, you already filed it?
I'll be filing.
We allow 2 weeks time to file a short rejoinder. Stop. Accordingly, it is the matter for hearing after 2 weeks. Rejoinder will be filed in the meanwhile. Yes.
15.
Yes, MS S. Langsti filed.
Your Lordship, we've already submitted our affidavit in opposition.
What about the Mr. 1?
We are not filing.
Not filing. So, we'll post it for hearing?
Yes, my lord.
Yes, Your Lordship.
The parties submit that the matter posted hearing. Accordingly, it's a matter for hearing on so and so.
Much obliged.
Please, Your Lordship, to kindly grant us 3 weeks' time to file the rejoinder
How
affidavit.
many times you've prayed?
This is the third time, Your Lordship.
Third time? Why 3 weeks time?
Because we still haven't received
What's the matter about?
the instruction.
Compassionate appointment, Your Lordship. Compassionate appointment.
We'll give you, what's your name?
Miss P. Dolai, Your Lordship.
Oh, you appeared last time also. Yes, MS Peter prayed for the last opportunity of 2 weeks to file rejoinder. Yes, list after 2 weeks.
17.
May I please, Your Lordship? Your Lordship, in this matter, I pray for 2 weeks' time to file my rejoinder affidavit.
You already allowed last time 2 weeks time.
Only one.
This is the first time.
Second time.
Okay, yes. Further 2 weeks time is prayed allowed for the affidavit.
18.
My lord, 18, 19, 20 and 21, my lord. These are connected matters. Affidavit has been filed, we have received. We will not be filing our rejoinder, my lord. Let it come for hearing after 2 weeks.
Yes, party submitted please are complete. This is a matter for hearing after 2 weeks. FCI matter?
My lord, yeah. My lord,
Sorry,
supply,
MIDC?
civil supplies.
No,
not
that.
Food and civil supplies, my lord.
22.
Lordship, I have received the affidavit filed with respondent, and item 22 and 23 are the analogous matter.
What?
22 and 23.
Yes.
Your Lordship, I pray that these two matters may be listed together with WPC number 72 of 2025. They are on the same subject matter.
What's the subject matter?
Lump sum compensation for permanent disability.
72?
72 of 2025.
This matter is Ashok Kumar.
Yes, Ashok Kumar and Ramesh Chandra.
Is that correct, MS Mirchan?
Lordship.
It's correct. All 3 matters are with regard to disability.
Yes, Lordship. Lump sum compensation.
Yes, MS A. Sundram, you want to file rejoinder?
No, Lordship.
Submits that no rejoinder will be necessary to affidavit filed by the respondents. He further praised that the 2 matters, that today's item 22-23, be listed together with WPC 72 of 2025 as they are on the same subject matter. The same not objected to by MS Mirchan. List after 2 weeks for hearing. Yes, these matters are 2 weeks for hearing.
24.
Yes. My lord, I'm appearing on behalf of the board. I got a little instruction, my lord, on this. Since my lord, there's mediation happening, can you refer this matter for mediation also?
They're supposed to file it. The last occasion was given on the last time. It is mentioned that affidavit is expected to be on board.
Yes, my lord, that's true. I am not denying the fact, but the fact that is the instructions that I have received. Because it's a 1978 matter, my lord.
You don't agree for mediation?
We can send it, but them also file
agree or not?
Okay, I agree.
Okay.
78 matter, my lord. 1967 it was required.
Yes, I order for mediation. Yes.
Much less.
25.
Okay, so let's your use, Mr. Sarma. You say yes. Yeah, this is the court, not your friend.
Yes. We'll try to explore that.
Yes, Dr. Agarwal.
This is a matter where the petitioner had passed her net exam since 2023, but yet to receive the certificate. Now UGC has stated that they are not the authority, and it is the respondent number 4. Respondent number.
Whose authority?
The number 4, National Testing Agency, number 4. Well, you have already served a copy on them. Affidavit also is on record, no?
No one's appearing for number 4. You're appearing for a National Testing Agency?
No.
Where are they located?
Well, we have filed an affidavit of service also. Okhla Industrial Estate, New Delhi. Well, you will see at Annexure B, page 5 of the affidavit. There is urgency in this matter because the petitioner has applied for several posts due to the non-issuance of the certificate.
Yes, though an affidavit has been filed indicating service upon the respondent number 4, which is the concerned respondent for issuance of the
national
NET certificate. Yes. No appearance is made on their behalf today. Stop. What, number 3? You have no contact with number 4? Yes,
the results also were declared by them.
By UGC?
No, by the
Stop. It is noted that the certificate issuing authority is the respondent number 4, in as much as where the results measure 4.
Page 12, no?
In as much as the results also have been declared by the said respondent number 4. Stop. It is not understood as to what has prevented the respondent number 4 from issuing a certificate or from not appearing, in as much as it is undisputed that the writ petitioner has qualified since the year
2023 June,
and due to the non-issuance certificate has been prevented from seeking gainful employment. Stop. Is there any other authority we can alert? Yes, in this view matter, let a copy to this order. In the interest of the justice, however, a last opportunity is granted to the respondent number 4 to make an appearance, during which further orders will follow. Stop. A copy of this order be transmitted by the registry also to the respondent number 4 by obtaining the correct email ID or any other form of correspondence. They'll have the correspondence, whatever it is.
It's on record.
You can't deny. You part 23, the net certificate is essential. Yes.
In terms of the last order, Lordship, the respondents were supposed to come with the...
My Lord, I enter appearance for 5, 6 and 7, my Lord, private respondents.
What about 8, 9 and 10?
Lordship, we have taken fresh steps in respect of 8, 9 and 10.
8, 9 and 10, I have no instruction, my Lord. Only 5, 6 and 7, my Lord. My Lord.
Yes, Mr. S.K. Hassan. Did you appear last date?
No, my Lord. Today I enter appearance. I received my wakalat number.
Hassan
I'll file, my Lord.
Has entered appearance today on behalf of respondents numbers 5, 6 and 7. With respect to respondents 8, 9 and 10, Mr. S. Chanda submits that fresh steps have been taken.
Lordship,
Respondent 1 to 4 I have filed.
in fact, on the last occasion, Lordship, by order dated 17/6/25, Lordship had directed the police authorities to file a status report with regards to the second FIR, Lordship, because
I have filed the affidavit. I have mentioned the affidavit, Lordship.
But in fact, my lord, the writ petition, my lord, is not maintainable because the alternative remedy is there, my lord, in the CRPC.
This is after 1 week, yes, for orders. And for appearance of 8, 9 and 10. We'll dispose of next day.
27.
27.
Hey, please, Lordship, I'm in the course of filing my rejoinder today.
You sure about that?
Lordship, yes, it's in the process of filing, Lordship.
Mr. S. Deb submits that rejoinder, we file across the day. If the same is not done, we'll impose cost.
Lordship, it's already in the process of filing.
Or just a matter for hearing.
For the matter, item 29 is also connected matter.
29 also. 27 and 29.
27 and 28. It's mentioned in the cause list. Obliged.
28. We will not be taking up hearings today. The hearings will just stand over to next week. Regarding to the matters, you have a hearing matter, Mr. Paul?
There's one matter that was heard, my lord, judgment reserved and then released. My lords had permitted them to file an affidavit.
Golf matter.
You filed?
Yes, ma'am.
In the hearing list?
Yes,
it's all the hearing.
Urgency is there?
We can do it Monday, Tuesday, subject
to my lord's convenience.
Which item is it?
Item 38, my lord.
Golfers,
Meghalaya Golf
Promoters Society.
Item number?
38.
Item 38 on the joint submission of the parties. This is a matter for one. You just take the date. So this matter needs
28. Fellows, would it be convenient?
28 we are chock-a-block. We'll have it on 30th.
30th.
It's 30th. We'll have some difficulty, but it's the some other matters are listed before bench 1. They probably take up the
bench
whole.
Bench 1.
This matter shouldn't take more than 10-15 minutes. My lords have heard us at length.
Because we've heard full substantially.
Yes. 30th.
Deep.
Or 30th we have that evidence election. So, okay, we'll have it on 29th then.
29th.
Mediation matters. Mediation.
Yes, mediation matters. See, all councils, you know what is the list. Correct.
Item 54, Your Lordship. We'll just go for mediation.
Don't mention.
Oh, yes.
I'll ask for mention. Call about, yes. Finish it. Only about the hearing matters. Corrupt mediation.
Supplementary list for mediation. Item number 4.
Well, this is in relation to pay. This can go, my lord. Item 4 and 5.
Yes.
This can go. 4 and 5, my lord.
This can be sent, please.
So 4 and 5? Yes. Yes.
Your Lordship, of item 4, Your Lordship.
You don't want?
No, Your Lordship.
Why?
It has been pending since 2022, Your
That's
Lordship.
why mediation helps.
And
pay, my lord, it has to. It can be mediated.
Also, Your Lordship. It has been fully heard and.
See, mediation will ease the pain which you are suffering so long. If it works out. It doesn't work out. It's only you have to come one session. Doesn't work out, we'll hear the matter. Yes.
Service benefits, Melissa. I think
be open to,
these things.
Yes.
More amenable to settlement.
Yes.
6.
5 more, yes.
6.
Item number 6 also, my lord. It can go, my lord. It's all about the pension benefits, my lord.
7.
The problem, she is old lady, Lordship. I have to represent in the mediation. Lordship.
Authorization.
7. 7.
4, 5, 6, 7.
Please, Your Lordship, this matter cannot go before mediation.
We have the same opinion, my lord. It cannot go for mediation.
8.
My lord, item number 8 can go, my lord, because we hope that the main respondent, Dorbashnong, may appear before mediation, my lord. They have not appeared. The matter has gone ex parte against the Dorbashnong, my lord. Allotment of land at Rinja, my lord.
You are appearing for the bank. Mr. Nobody appearing for the
Muda.
Yes. So 6, 7 won't go.
Yes, my lord. They have not.
8 will go.
8 can go, my lord.
8, but mediation, the parties have to be there anyway.
We can make a try, my lord.
9. 9.
Please, Your Lordship, this matter, we are not willing to go for mediation from the government, Lordship.
Okay.
Much obliged, Lordship.
10. Item number 10.
Lordship, we are ready for the mediation.
Yes, Your Lordship.
Ready?
Because there are other connected matters also at the same time it might get resolved. So.
Yes.
11.
11 can go. As a matter of fact, on order dated 21/7, my lords have also indicated that.
11 years.
12.
My lord, 12, 13 and 15 can go, my lord. This electrocution case, my lord. 12, 13 and 15.
What about 14?
14 is not a connected matter, my lord.
14,
12, 13 and 15 is connected.
Yes.
14.
You can go for petition.
14.
We can go for petition. Yes, Mediation can go. No.
I don't have instructions in this regard, Lordship.
Yes or no?
We are
What is the case about?
This is a case about that they have discontinued scheme, and thereafter we are out of job. So, but now we are.
What scheme is this?
KVK scheme from the
Department of Agriculture.
Although they can't go then for mediation. Because it's not a question that they can.
Okay.
Yes.
16.
Much more.
16.
Please, Your Lordship. Your Lordship, this matter can go for mediation.
Yes.
No objection.
Not the objection, should be also willing for mediation. Yes.
Daily list 39. Daily list 39.
Hearing.
This matter can go for mediation, Your Lordship.
39 can go. Yes.
40.
40.
40 also can go, my lord.
Where's MS Imran? Yes.
I have an objection, Your Lordship.
Objection? No. Why?
Because, Your Lordship, as per our affidavit, the land that the petitioner is claiming during the inquiry, they cannot identify the land, Your Lordship.
That is why, my lord, mediation, my lord. Whether this can be settled down between the private respondent and the
No, I don't
petitioner.
have instruction, Your Lordship.
We don't agree then.
My lord, my lord.
41.
No. 40.
This can go, my lord.
No, this can't go, my lord. Sorry.
This can't go.
No, my lord, because initially they had referred to the for mediation, my lord, but it was not fruitful, my lord.
Which one?
Once more, my lord. If previously it went.
Pension matter?
No, my lord. This is for appointment, my lord. There's a my lord, select list and waiting list, my lord.
As per my instructions, my lord, can't.
We're not agreeable. Sorry. Yes.
42.
This is the
Yes,
church matter,
yes,
my lord.
already yes. Already agreed, yes.
43. 43. 43.
Yes, Suna. No one's here. Policeman Monday. Alone list me again. Yes.
My lord, let it come again, my lord, because we also have.
Because we have only 2 days for this referral.
My lord, Monday, my lord.
Yes.
Because we have to take a consent from, because we have 3 departments involved here, my lord. So only one department has consented.
44.
44 we can send, my lord. From the petitioner side, we are ready, my lord. If the
My lord,
state.
from the state side, we do not want it to be sent to mediation, my lord.
Why?
Mr. AAG has informed that it cannot go for mediation. It has to be heard by
I
the
don't
school.
want it to go.
My lord, yes.
On his own personal capacity or?
My lord, based on the merits and the materials on record, my lord.
You know.
45.
45 also can go, my lord.
45 can go, my lord.
Okay.
46.
No, 46.
This is probate matter, no other side.
No, we will pass order.
Yes, my lord.
No, yes.
47.
My lord, we can try for mediation this one.
It's a, what is, oh yes, this is a good,
47.
this is a property dispute, correct?
2 wives fighting over the
Sorry,
pensioner.
probably, yes.
Yes, my lord.
Yeah.
48.
You agreeable?
No, not.
No. You want mediation, Mansur?
If they don't want it, it's okay, my lord.
Okay, no.
49. 49.
Just the one sweat. Nobody, okay.
50.
50
No.
cannot go, Lordship.
No, Lordship.
What's the matter about?
Promotion.
Promotion, Your Lordship.
Okay.
51.
51.
Can go, Your Lordship.
It can go.
This matter has been already sent to reference court, my lord. But if they want to make a trial, we have no objection, my lord.
Yes, 51. Yes.
42.
52.
52, sorry. 52.
My lord.
matter cannot go for settlement.
Cannot go. Okay, no.
53.
Can try mediation. Yes.
54.
We'll go for mediation, Your Lordship.
Yes.
55.
Agreement, Mr. Abraham?
Yes, agreeable, yes, Your Lordship.
Oblige.
Yes.
55.
My lord, we are open for mediations, my lord. Go, Lordship.
This one, yes, it's a good matter of mediation. Yes.
56.
Much obliged.
Lord, this cannot go, my lord. This is
Yes, my lord.
essential services.
Cannot go, my lord.
Is regarding?
Mobile tower, my lord.
Construction of mobile tower illegally.
Essential services, my lord. There's law in place, my lord. Policy in place, my lord.
Or on your land?
Yes, my lord.
we are the landowners.
It's a right land. It's a right land, my lord. I am the community. I am the member who is cultivating in that area.
57.
57 cannot go for mediation unless this is the
Yes.
order of the.
No, again. Right.